Mark, are you here in the studio?
I am, yes. Nice to be here. Thanks for inviting me, Ripon.
Mark, well, clearly you have a great wealth of experience and knowledge in the context of housing. Please briefly summarize it for us.
I work as a housing policy officer at Tower Hamlets Council. I've done that for nearly 3 years now. Before that, I worked for many years at Shelter, and before that, I worked for very many years at different housing associations and homelessness organisations.
All right, clearly, from my point of view, homelessness is a serious crisis. But
Absolutely.
practically speaking, what is homelessness? Do we define homelessness?
Gosh, well, there's many different ways. I mean, there's many ways to do that. I mean, in an obvious sense, homelessness is not having somewhere adequate to live that is secure and relatively stable. So that might manifest itself as, for example, having to sleep on friends' sofas. It might be having to stay in very short-term accommodation. It might mean moving between different people's floors. It might mean sleeping in the car. It might mean sleeping on the street at the extreme end of things. From a local authority perspective, there are many different ways to define homelessness. Again, local authorities define it through the Housing Act, which is about not having somewhere suitable and accessible to live. So if you don't have somewhere that meets your basic needs and that isn't somewhere that you can have access to, then you are essentially, from a local authority perspective, homeless.
So I completely understand that you can't obviously take a kind of a political stance, but from the point of view of causes of homelessness based on research that you may have read, based on analysis, what are the main causes you come across these days?
Well, again, there's many ways to do that. From a kind of broader perspective, there is something about just the wrong kind of housing being built. There's too much housing that we can't afford to live in. It's built in order to park people's money. It's built as investments. So that's kind of a more structural level. In terms of kind of immediate causes of homelessness, the most common cause of homelessness for the last few years has been loss of a private rented tenancy. So it used to be that generally people became the most common cause of homelessness was a relationship breakdown, somebody being kicked out of a family home, a marriage breaking down. That's no longer the case. The most common reason that people present to local authorities as homeless is they've been renting somewhere from a private landlord, and the private landlord has told them they have to leave through no fault of their own, but simply because the law allows private landlords to, generally speaking, ask you to leave at 2 months' notice.
So is that when we're dealing with Section 21?
Yeah, that's right.
So tell us a bit more about Section 21.
Okay, well, Section 21 of the Housing Act allows a private landlord to give notice to their tenant without any stated reason. So the tenant doesn't have to have done anything. The landlord can give notice, just has to give 2 months' notice and has to give it in a specific written legal form. There are restrictions on when the landlord can give that Section 21, which is always very useful as a tenant to know. And if you don't know what the restrictions are and you get a Section 21, go along somewhere and get some advice, because it could be that the landlord doesn't have the right to serve you notice. But essentially, the simple way to see it is if you're not in the fixed term of a tenancy, so if you haven't signed an agreement, for example, for 12 months and you're still within that 12-month period, then a landlord can serve you with a 2-month Section 21 notice. And at the end of that Section 21 notice, If you haven't left, and sometimes it's not possible to leave, the landlord is then entitled to apply to court to have you evicted.
So I'm going back to section 21 because I do want my listeners to kind of get a grip of it. Okay, so obviously 2 months notice, we've got that. So is there any ways where landlords make mistakes?
Landlords often make mistakes about section 21s. There might, for example, be a mistake with the wording of the notice that they give you. It has now to be in a specific legal form, the form of wording. So if they don't give you a correctly worded section 21, then it's not valid. It doesn't mean anything legally. If a landlord makes a mistake with dates on the section 21, it has to give you at least 2 full months of notice, and it has to end on the day that a tenancy period ends, so that landlord will often make a mistake with that. Those are 2 of the most common mistakes that a landlord makes. There are also a whole set of restrictions, some of which have come in quite recently, restricting when a landlord can serve you that kind of notice. Now those for example might apply when a landlord has taken a deposit from you but hasn't protected that deposit in the way the law requires, or it might apply when a landlord is in an area, in a local authority area that requires them to have a license, and they don't have a license. It might be, and this is fairly new, if they are required to have an EPC rating of a specific level, and they don't
What
have
is
that.
an EPC
So that's
rating?
that's about energy efficiency. So if a landlord doesn't have, if a landlord is letting you a property that is an E rating or below, then they're not allowed to be letting it to you. And one of the follow-ons from that is that they're not allowed to serve you notice. The most common ones I think to look out for are wrong wording, the fact that a landlord hasn't protected a deposit, or the fact that a landlord doesn't have a license. My advice would be, though, is if a landlord serves you a section 21 notice, if a landlord gives you notice of any kind to leave somewhere that you are renting from them, if you have a problem leaving, then go and get advice, because it is not uncommon that a landlord gives notice in the wrong way, and then that notice doesn't have the legal force that the landlord needs it to have.
So in what way section 21 is different from section 8?
Okay, so if you're renting privately, if you're renting from a private landlord, in other words, you're not renting from the council and you're not renting from a housing association, so it's not somewhere you've got through the housing register, then effectively there are 2 ways that a landlord can evict you. The first is through section 21, and as I've said, there are restrictions on that. The second way is through something called section 8, and that private landlords don't like using, so they very rarely use it because it's a lot more complicated. The key thing is that if they use a section 8, they have to not only tell you in writing what it is you've done to break the tenancy agreement, but they then have to prove that in a court of law. So it tends to be that landlords don't like using section 8s.
So, I mean, I suspect there are kind of like a restriction, isn't there, in section 28 when landlords are using them when they have to. So what are the common ones that you may come across under section 8 when landlord is bringing a claim or serving section 8?
Generally speaking, it will be for rent arrears, or for another breach of tenancy, so something like antisocial behaviour. But it has to be that the landlord states exactly what it is you've done, states how that breaks the law, and then, as I say, takes you to court to prove it if you don't leave when the notice ends. There are, from memory, 14 different reasons that a landlord can kind of list as to the form of tenancy breach. The most common will be around rent arrears, which are grounds 10, 11, and 8. And the difference between some of the reasons that a landlord gives are what are called mandatory. So, in other words, when that comes to court, if the landlord can prove that you have broken the tenancy agreement in that specified way, the judge has to evict you. Some of them are discretionary. And
so, could you give us a few examples of mandatory and discretionary?
Okay, so the most common mandatory ground is that you are 2 months in rent arrears, and that's ground 8. And if you're 2 months in rent arrears on the day that it comes to court, and the landlord has set out that he's evicting you, or he's seeking to evict you under ground 8, then the court will have no discretion on the matter. They will have to evict you. If it's a discretionary ground, for example, that you have been late paying your rent, or persistently late paying your rent, then the court will have a bit more discretion, and they will look to see, well, is it really reasonable to evict you, or is there good reasons for it? So I would say those are the most common grounds.
So so where does a deposit scheme fits into those two things?
Yep. Okay, well, like I said earlier on, if a landlord takes a deposit from you, they have to protect it in a deposit scheme, and if they don't do that, there are restrictions on serving Section 21s to evict you. Which, from your point of view, is probably a good thing, because it gives you more security of tenure. But what the law says is that when a landlord takes a deposit from you, this is not rent in advance. This is a deposit which the landlord keeps until the end of the tenancy, with the understanding that they will give it back to you at the end of the tenancy, as long as you haven't, I don't know, stained the carpet, broken the toilet, whatever. The law says now that within 30 days of you handing that money over, the landlord has to register it with the deposit protection scheme, and give you proof that they've done so. Now, if they don't do that, then you automatically have the right to take them to court to claim compensation from them. And the reason that's there is because it used to be very common. It's still not uncommon, but it used to be very common that a tenant would hand over a deposit at the beginning of a tenancy.
Yeah.
At the end of the tenancy, they've been a good tenant. They haven't broken the sofa.
Yeah.
They haven't caused any damage.
Yeah.
They ask the landlord for the deposit back.
Yeah.
The landlord doesn't give it back. The landlord just keeps it. That was a common problem. If that deposit has been protected, as the law now requires it to be, then it's actually hard for a landlord to do that, because the tenant can contact the scheme with which it's protected. It might be that that scheme is physically holding the money, or it might be that that scheme has insured it. The tenant can contact the scheme, and the scheme will very quickly and very straightforwardly make a judgment about what's fair. So it's definitely in a tenant's interest for that deposit to be protected, because it effectively ensures that at the end of the tenancy, as long as you haven't, it ensures that at the end of the tenancy you get the deposit back in a fair way. If you've caused £100 worth of damage, the landlord's entitled to keep £100. If you've caused £50 of damage, the landlord's entitled to keep £50. But the landlord isn't entitled to keep the whole thing, and the landlord isn't entitled to make sort of spurious claims about you having caused damage.
So what happens if the landlord does that, keeps the deposit, and you think the reason landlord kept the deposit is unreasonable, then what steps can you take?
Well, if it's protected with a deposit protection scheme, then you should contact that deposit protection scheme straight away, and explain to them what the problem is, and they will take it from there. They'll look into it for you, they'll contact the landlord, and then they'll make a judgment about what the correct outcome is, and if they find in your favour, they'll make sure you get the money. If it's not protected with a deposit protection scheme, then it's a little bit more complicated, in that you have to make an application to a small claims court.
Mm-hmm.
And that's relatively straightforward to do. You might need a bit of help and advice to do it, but it's relatively straightforward to do. If you are on a low income, then it might be that it's free or discounted to do that. If you're not on a low income, it's going to cost you about £100 to do that. You'll get it back. If your deposit is not protected, the court undoubtedly will award you compensation, and that compensation will be between 1 and 3 times the value of the deposit. And in addition to that, they'll also order the landlord to return the deposit to you. So you can see that potentially they will order the landlord to return you a substantial amount of money. It might be they order the landlord to return you, if they think the landlord's deliberately withheld deposit money from you and not protected it, they'll order the landlord to pay 3 times the value of the deposit and give you the whole deposit money back. So you end up with an award of 4 times the value of what you gave to them.
Fantastic.
I mean, you then run into difficulties actually physically getting that money, but you can pursue that through the normal.
You have the
channels.
option and the right to do so.
Absolutely.
Now,
and generally, landlords will
will
buckle and give you your money back.
But tell me then, let's say if you have spent a great deal of money due to the fact that landlord has not done repairs that need doing, and you've incurred cost as a result of a disrepair.
Yes.
What options do you have then on?
Well, unfortunately, if you've spent money making good repairs that the landlord should have repaired themselves, it's actually very difficult to claim that money back.
Is there any way it's not possible to get it off the rent?
Not really. There is a procedure by which you can do it.
But I suspect the person needs to seek advice on this.
You definitely need to seek advice before you do that. It's that people kind of, for totally understandable reasons, the landlord is behaving totally unfairly and frankly illegally by not doing repairs that they're required to carry out. Obviously, one remedy for that is to do it yourself.
Of course.
And quite rightly, you'd think, well, I can reclaim that through the rent. Unfortunately, the law would look at it slightly differently. If you're in that situation, go and get advice from a housing advice specialist.
Fantastic. Now, tell me briefly about the legal process. Clearly, we talked about Section A, we talked about Section 21, we talked about repair, disrepair, and also deposit scheme, amongst other things. So what is the standard legal kind of process in the context of kind of like, let's say, possession?
Okay. So if you are renting, I mean, again, we'll talk about private land. Well, actually, I mean, if you're renting, whether you're renting privately or from a social landlord, there is a sort of standard form.
Yeah, let's focus on this.
Where it's different is if your landlord is living in the same flat as you are.
Yeah.
So if you share a bath, basically, if you share a bathroom and a kitchen with your landlord, it's actually quite easy for them to evict you. So this doesn't quite apply in the same way. If you're in that situation, you still have legal rights, but they're quite different. They're not as strong. But if that isn't your situation, in other words, your landlord doesn't share the bathroom, kitchen, or living room with you, then there are a series of steps that a landlord must follow if they want to force you to leave. Obviously, they can ask you to leave at any time, and you can decide that you're going to leave, but you don't have to, because as a tenant, it's your home.
Yeah.
It's not your landlord's home, and you have protections. Your landlord has to follow the legal process if they want to remove you from your home, and that is that first of all they have to serve you with a legally correct written notice, and that notice gives you a period of time at the end of which your landlord would like you to leave. That might be 2 weeks or it might be 2 months, depending on the kind of notice that they're giving you. At the end of that period, you don't legally have to leave. If your landlord tries to force you physically or in any other way, then they're breaking the law.
And lawful eviction?
Absolutely, and you should get advice.
Absolutely.
And potentially speak to the police about that.
Yeah, absolutely.
But if for whatever reason you can't leave at the end of that notice period, or you don't want to, then the landlord would then have to apply to court for an eviction warrant, or rather a possession order. I mean, one way to look at it is this: is that a landlord can never evict you. A landlord can never force you to leave your home. Only a court can do that. A landlord can give you notice. At the end of that notice period, the landlord then has the right to ask the court to grant possession.
So what if you have a defence? Then what?
Well, if it's a section, well,
Yeah, you see,
yes,
yeah,
if you have a defence, then the court will decide whether or not to evict you. As I said, with the Section 21, and as you said, Ripon, with the Section 21, there are restrictions on when a landlord can serve it. So that might be your defence. It might be the landlord's given me a Section 21, but he didn't protect my deposit.
Sure.
So that's my defence. And the court, if that was true, would say to the landlord, no, we're not going to evict this person. If the landlord has served a Section 8 notice and is seeking possession on the grounds that you're in rent arrears, you go to court, you show them that you're not in rent arrears, or that there are very strong extenuating circumstances why you're in rent arrears, then the court again may decide that they're not going to evict you. So if you have a defence, you can put that defence to the court, either by going along yourself, or preferably by getting advice first of all, and having somebody represent you. Now, you can get advice from a range of places. I guess we'll get on to that. But ideally, it would be from a housing solicitor or a housing expert.
So, I mean, let's say you're on the verge of eviction,
Yes.
and you have children, and you may have other health problems,
Yes.
and your landlord is saying it's time to go. I've followed due process.
Yes.
So, in what context local authorities can help you? In what? Yeah.
Well, local authorities. I mean, I should have said this at the outset, especially being from a local authority.
Yeah.
But local authorities have a very much expanded duty now to get involved when somebody is threatened with homelessness. So if you are threatened with homelessness, actually the first place you should go for assistance is to your local authority.
Why is that?
Because local authorities have a legal duty to try to prevent homelessness from happening. So if you go to a local authority and you're at risk of homelessness within the next 56 days, so essentially within the next couple of months, then a local authority has a legal duty to try to make sure that you don't become homeless. Now, there's a number of ways they can do that. It could be through making sure you have correct legal representation to make sure that you're not evicted in the first place. It could be through looking at whether there are financial ways in which they can help you negotiate with the landlord, maybe make an arrears agreement, maybe make a contribution to paying off some of your arrears, or it could be that they help you find somewhere else to live before you become homeless. So a local authority has quite considerable duties to help you if you are threatened with homelessness.
So when they look whether to support you or not, what sort of things are they looking out for?
Well, if you're threatened with homelessness, they will help you, or they legally are required to help you, as long as you are what's called eligible for assistance. Now, unfortunately, you are not eligible for assistance from any local authority if you have no recourse to public funds. Now, increasing numbers of people have no recourse to public funds because the government over the last 8 years has been very keen, when they give people leave to remain, to give it on the basis that they don't have access to public funds, which makes life exceptionally difficult for those people.
For many, absolutely.
Which is disgraceful in my view.
Sure.
a local authority also, you may also not have recourse to public funds because, for example, you're an asylum seeker, in which case your homelessness should be dealt with by the Home Office.
Absolutely.
One of their agencies. What is it now? UK board, right? Not,
well, they can
now
do it. There are two
UK
ways, isn't there? I mean, if you are, so it's more in line with Home Office, really.
Yeah, it's the Home Office.
Yeah, it's the Home Office.
So
The Home Office has arms.
if you're
yeah.
an asylum seeker, you haven't yet
Yeah,
been
yeah.
granted asylum, then the Home Office has a duty to provide a form of accommodation.
So let's say you are a British citizen, okay?
Yes.
So you have the right of abode,
Yeah.
and also you're found to be homeless.
Yeah.
Does that mean the local authority would help you? I mean, with a new home, or what's going on?
Well,
So there we are.
So if you are eligible for assistance, so that might be, as you say, because you're a British citizen, or it might be because you have leave to remain. You're not a citizen, but you have leave to remain.
Yeah.
Or it might be because you are a European national who has every right to be here. As long as you have a history of working, the local authority will have a duty to help you because you're eligible for assistance. So assuming all that applies to you, if you're threatened with homelessness, the local authority, regardless of anything else, has a duty to try to help you not to become homeless. However, if they can't prevent you from becoming homeless, then they start to apply other tests to see whether they'll help you further.
Briefly, what are the tests?
So the other tests are, the main one is, are you in priority need? Now, in order to be in priority need, you will either need to have dependent children or to have significant health problems, to put it simply.
Okay. Clear. I mean, so what? Do you have to fill in a form or anything? How does it work?
You go along to, you absolutely don't have to fill in a form. You go along to your local authority, to their housing options department, and you, if you can, you take as much evidence with you as possible that either you have dependent children or you have some kind of medical problem that makes it harder for you than for most other people to be homeless. So that might be that you have, for example, significant mental health problems. It might be that you have significant physical health problems. It might be that you've got particular history. Again, get advice. If it's not straightforward, if you don't have kids or you're not pregnant, and go and get advice. But no, you don't need to fill in a particular form. If a local authority tries to make you do that, then they're not acting lawfully. I mean, they may ask you to fill in a form, but they can't require that as part of your homelessness application.
Well, on that note, Mark, I would like to thank you for coming on your Money Matter show. And hope to see you. Hope to see you in the future.
Well, that'll be lovely.
Listeners, what we'll be doing now, just take a brief break, and then we'll come back and listen to what members of the public think around homelessness and eviction. And of course, another topic we will be covering is about car finance.
Thanks. Done?
It's done. Thanks very much. Thank you.